1. Hi everybody, I'm Griffin Bridgers. It's my pleasure to introduce Griff's Notes for today, January 3rd, 2022. Griff's Notes is a series that covers some of the cases that I determine to be of the best value across the country, which I then present to you in a hopefully spoon-fed fashion. If you want to read more about the cases we're going to discuss today, you can visit my newsletter, which you can find at griffinbridgers.substack.com, linked in the video notes below. For the time being, I want to remind you that 1, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only, and 2, that this video cannot be relied upon to assess the health of your own estate plan. That being said, let's go ahead and get started. We have 3 cases to discuss today from all around the country, 1 from Maryland, 1 from Florida, 1 from Minnesota. So we've got a good representative slice of the East and the Midwest, but as I said, if you want to learn more about these cases or read more about them, you can visit my Substack newsletter linked in the video notes below. To start out with, Ahmad versus Ahmad, I'm not going to go into the facts of this case, but essentially what was at issue was a beneficiary of a revocable trust that had been disinherited. He was one of 3 children of the decedent and settlor of the revocable trust, and then settlor died, trust became irrevocable. This child and beneficiary came out of the woodwork to say, hey, I want to challenge my disinheritance, but it was being challenged on the grounds that he wanted Iranian civil forced inheritance to basically supersede the disposition of assets under the trust itself. But we didn't even get to that issue of conflict of laws, because what the court determined here, the Court of Appeals determined, is that the statute of limitations for challenging a revocable trust begins to run when the potential injury is discovered and not when the injury actually occurs. So the beneficiary in question here had received a copy of this revocable trust, which was unaltered prior to the settlor's death, but he had received it back in 2007. There was a 3-year statute of limitations which had run well before this action was ever brought. So because of that, this was an issue interpreting the statute of limitations, which once again really set the standard for determining when that statute runs, being based on the discovery of an injury and not the actual injury itself. And that holds true in the revocable trust concept or context, even if the settlor is living and still has the intervening power from the time of discovery to prevent that injury by amending or revoking the trust. So this has a lot of potential application on both sides of the fence, both drafting and potential challenge by clients, and it may create issues down the road if this is the common trend, but I give this case a value-added score of 6.5. We're going to go down to Florida, the Florida Court of Appeals in the case of Tendler versus Johnson, and the key takeaways here are that 1, whenever a probate is opened, a notice of administration is served on potential heirs and beneficiaries, and that gives those heirs and beneficiaries just a 3-month window to challenge the validity of the will itself, whether it was validly executed and followed formalities and should be admitted to probate. Now, what happened here wasn't a challenge to the will itself, but a dispute over the construction of a specific term or provision of the will. There was an attempted exercise of a limited power of appointment in a way which could have caused it to become treated as a general power of appointment. That issue aside, which I've spoken about before, this was the core of the challenge. It was to a construction of a specific term, but the beneficiary here wasn't challenging the validity of the will itself. But the trial court determined an interpretation of the will to be a challenge to the will and determined that such a challenge was time barred because it was beyond this 3-month window set forth in the notice of administration. However, the Court of Appeals here said the trial court was wrong. A simple question of interpretation doesn't rise to the level of a challenge to the validity of the will itself, because the validity is based on execution and not on language itself. So, issues about construction and interpretation, at least in the state of Florida, are not time barred, even if they arise more than 3 months after a beneficiary's receipt of a notice of administration. So I give this case a value-added score of 4.5, really because it's just interpreting and supporting an already existing statute and a law and rule that had been covered in prior cases in Florida itself. Finally, we have a case in Minnesota which seems counter, or really, I wouldn't say it seems counter or anything. It's really intuitive and really supports what the Uniform Trust Code says to begin with. So there's really no new law here. I give this a value-added score of 3, but I bring it up because this is a consistent drafting issue I see come up that might be incomplete based on this case, and might be incomplete when you consider certain trustee duties that weren't really addressed in this case itself. But long story short, beneficiary here brought a challenge seeking to modify a trust for which the primary asset was farmland. The beneficiary was one of 6 siblings. They wanted to sell this farmland, but the trust had language that said, you can't sell land. So the beneficiary wanted to modify the trust to get rid of that express restriction on the sale of the land, because the land wasn't doing as well as it could have. Its value was going down. The beneficiaries were only entitled to the income from the land, which was only about 2.7% annually. And obviously they could do better economically by selling the land and reinvesting the proceeds. Not to mention there were some other issues going on in the background, but ultimately what the court found is that if there's language that expressly states that property cannot be sold, that is a material purpose of the trust. And even if you get the consent of all beneficiaries, the UTC expressly states that you cannot modify a trust if doing so would violate a material purpose of that trust. And in this case, we had specific language, which superseded over general language. Now, the general language could have otherwise permitted a sale of property, such as for payment of estate taxes and other situations, but just because the general language contemplates a trustee's general duties and powers to maybe sell land, that does not supersede over specific language that says, do not sell the property. You just can't get around that. And I also want to note here that the material purpose superseded over obtaining the best return for the beneficiaries as well. So even if, as a trustee, you can do better, this should give you some comfort that if there's express language saying, do not sell the land, potentially that overrides and waives your duties to prudently invest and diversify. So you needn't worry yourself with that, but in this case it was a beneficiary and not the trust bringing the challenge to begin with, which is probably why those trustee specific duties of prudent investment and diversification weren't actually addressed here. But either way, I only give this case a value-added score of 3 because it doesn't really add new law or even interpret existing law in a way that we didn't anticipate. This is really facts and circumstances specific, but I think it still has good value when it comes to client interviews and drafting. Because if you have a client who wants to include a family heirloom asset and tell the beneficiaries not to sell it, you need to be able to tell them, hey, this could result in litigation in the future if this does not return the best economic benefit that it could in the market. So under which circumstances would you consider a sale of this property? And if it's a hard no, if you don't want it to be sold at all, you should note that this could generate unanticipated expense to your trust and to your heirs in the future. But ultimately here, the trust wasn't charged for this, only the beneficiary who sought the modification was charged. As always, if you want to submit questions or topic suggestions or even case suggestions for Griff's Notes, you can email those to me at griffin.bridgers@gmail.com with the caveat that I cannot give legal or tax advice in response to your questions. This is not an attorney solicitation. I want to note once again, this video cannot be relied upon to assess the health of your own estate plan. But once again, I thank you for joining me for this episode of Griff's Notes, and I look forward to seeing you in my future content.